Ahondona Nko, and Benin State University.
Yes, Mr. Ocha.
May I please, my lord, Ocha Oleg appears for the claimant.
Okay. Ocha is the second one. Ocha Olegede.
Yes, claimant, my lord.
Claimant. Yes.
Yes, my lord.
Yes. Mr. Aso. You are muted, Mr. Aso. You are muted, please. Mr. Aso.
He has touched something that kept him.
No, it's muted. We can't hear him. Mr. Aso, you are muted.
My lord?
Yes.
Yeah, my lord.
I can hear you. I can hear you.
Yes, my lord. My name is MT Aso.
Yes.
My appearance is for the defendant.
Yes.
Appearing with me is my learned friend GT Aqua Esquire, my lord.
GT.
Yes, G as in Gabriel, then T as in town, then Aqua AKO, my lord.
Okay.
Yes, for the defendant.
Thank you.
Thank you, my lord.
Sautan Aso.
Yes, my lord.
My lord.
Yes. We are so exhausted here. I'm not going to read the whole judgment. Just going to read some parts. And yes. So this suit was filed by the claimant on 29th of November 2018. It was commenced by a complaint and other accompanying processes wherein the claimant, in a statement of facts, seeks the following relief against the defendant. Number one, a declaration that the allegations of sexual harassment, attempted rape, and abduction of Ms. Whitney Vey laid against the claimant are criminal in nature, if the defendant lacks the power to investigate. Number two, a declaration that there is no credible evidence to establish the allegations of sexual harassment, attempted rape, and abduction against the claimant before the senior staff disciplinary committee to sustain the findings contained in the report submitted to the defendant. Number three, declaration that the defendant lacks powers to take disciplinary proceedings against the claimant for criminal allegations of sexual harassment, attempted rape, and abduction of Ms. Whitney Vey when the claimant was not tried and convicted by the court of law of the said allegations. Number four, declaration that the defendant's senior staff disciplinary committee constitutes investigate the allegations of sexual harassment, attempted rape, and abduction of Ms. Whitney Vey against the claimant was not properly constituted and competent to investigate the allegations against the claimant. The defendant cannot rely on the report of the committee to dismiss the claimant, and the purported dismissal of the claimant conveyed to the claimant by letter reference number P1387 dated 4th September 2018 is null, void, and of no effect whatsoever. Number five, declaration that the senior staff disciplinary committee of the defendant denied claimant right to fair hearing when he denied the claimant opportunity to call his witness in the person of Mr. Anchovo, and the police investigation report dated 3rd November 2014 during the proceeding leading to the report submitted to the defendant, which formed the basis for the dismissal of the claimant by the defendant. Number six, declaration that the senior staff disciplinary committee of the defendant was biased against the claimant when he secretly procured the written statement of Mr. Timothy and Chobo made to the police. The police report dated 3rd November 2014, but failed to make use of the same in arriving at the recommendations to the defendant. Number 7, declaration that the senior staff disciplinary committee of the defendant's findings to the effect that the claimant admitted during proceedings that he drove with her to his friend's house against her wish, where she was forced to stay, and advances made on her is not by the claimant, but it's a manufactured admission by the claimant, by the committee, and ascribed to the claimant. Number 8, declaration that the term inappropriate conduct between the lecturer and his female student, which is the senior staff disciplinary committee finding in its report to the defendant, is not punishable by dismissal under the defendant regulations governing the conditions of service for senior staff of the defendant. Number 9, declaration that the claimant is still in the employment of the defendant, entitled to salaries, allowances, promotions, and other entitlements of his office. Number 10, order of the court nullifying the letter of dismissal of the claimant dated 4th September 2018, and all actions taken consequent on the same. Number 11, order of the court directing the defendant to withdraw the dismissal and reinstate the claimant to work, and to pay to the claimant all his entitlements, promotions, salaries, and allowances. Number 12, order of perpetual injunction restraining the defendant by itself, agent, servant, previous, by all and through whomsoever, from further harassing and tampering with the employment of the claimant, irrespective of the said allegation of sexual harassment, attempted rape, and abduction of Ms. Whitney Vey. Number 13, an order of the court directing the defendant to write a written apology to the claimant, post the letter on the defendant's website, and publish later in 2 national dailies to correct the defamatory information previously published in the Benue State White Paper of February 2016. Number 14, general damage in the sum of 50 million naira. And number 15, interest on the judgment date from the date of judgment until the judgment date is fully paid. Mr. Gabriel. Yes, please, yes, can you mute yourself, please? So, for receipt of the noting process, the defendant filed a memorandum of appearance, statement of defense, and other accompanying processes via leave of court granted on the 20th of March 2019. Case of the claimant. So the case of the claimant that he joined the services of the defendant on the 14th of August 2008, across to the post of lecturer 1 with the defendant, Department of Political Science of the defendant, that he has been performing his duties diligently and honestly, and has never received any query concerning his duties up until 25th of September 2014, when one Dr. Vey brought a petition against him, accusing him of sexual harassment, attempted rape, and abduction of his daughter. The claimant was then given a query and subsequently issued a dismissal letter on the 11th of September 2018. The claimant alleged that the allegation brought against him is a criminal offense which the defendant lacks powers to investigate, that the composition of the committee that investigates the claimant is illegal, and that he was not given fair hearing. Case of the defendant. From the side of the defendant, denied the claim of the claimant and averred that the petition of sexual harassment, attempted rape, and abduction was filed against the claimant by the female student. The claimant was invited to make a presentation before the senior staff disciplinary committee before his dismissal, which was in accordance with the provisions of the regulations governing the conditions of service of the defendant. According to the defendant, the claimant was found to be in breach of Section 6 of the regulations of the defendant by committing a misconduct which attracts dismissal. Trial, I'm going to skip that. Submissions of the defendants, submissions of the claimant. I will go to my opinion.
God bless you.
Let me just read some parts. From the pleadings of the parties, the evidence produced and submissions of counsel for the parties, which I have carefully perused and examined, the fact leading to the claimant's case is that on the 5th of September 2014, one Dr. V wrote a petition of sexual harassment, attempted rape, and abduction of his daughter by the claimant. It was stated in the petition that when his daughter, as a new student, was about to sign her attendance register during her first semester exams of 2012, she was asked to stand by and wait for order from above, while the claimant came and asked for her phone number and asked her to meet him at a place later that day. But when she informed her father about this, he advised her to ignore the instructions. Further to this, it was also stated in the petition that on the 21st of September 2014, when Ms. They went to Simbo's Eatery, stayed at Makodi Bokoro to buy swear and drinks, she was forcefully dragged to the claimant's car, where he locked and drove off his car in a high speed and took her to judge's quarters. On the other hand, the claimant on his part felt aggrieved and as a result lodged a criminal complaint to the police against Dr. V and 2 others for threat to his life and defamation of his character. The police then, upon receipt of the said complaint, investigated the matter and issued its report and charged Dr. V and 2 others to magistrate court. However, they were later discharged. Following the petition submitted by Dr. V, the defendant on the 5th of August 2017 issued a query to the claimant, where he responded by Exhibit 7. And the defendant then constituted a disciplinary committee, which investigated the matter and issued its recommendation and report to the counsel of the defendant, while the counsel dismissed the claimant. It is the contention of the claimant that the allegations raised against him are criminal in nature and ought to have only been investigated by the police and tried in the court of law before his dismissal. Then the defendant lacks power to take disciplinary proceedings against him for those criminal allegations. I need to observe and make it clear that the senior staff disciplinary committee clearly stated that it has no powers to entertain the case of attempted rape and abduction, but it will only focus its investigation on the issue of sexual harassment. See page 1 of Exhibit 13. It was similarly one of the findings of the said committee that the application of undue and physical control with the intention to sexually harass Ms. V amounts to sexual harassment. It must be observed that the defendant did not pronounce on the incapacity of the claimant with respect to the allegations of abduction and attempted rape against Ms. V. It was merely investigated for sexual harassment. I need to stress here that, contrary to the claimant's contention, an employee has inherent powers to discipline its employee according to contract of employment, while the conduct of the employee constitutes a misconduct. But where such a misconduct involves a crime, he cannot impose punishment like the court of law. In the case of the Nabo and Buiki, it was held that the general rule is that, which is however subject to exception, is that where the dismissal of an employee is based on allegation of crime, that allegation must first of all be proved before dismissal can stand. However, the exception to such general rule is that it's not in every case that an employee must be arraigned before a court of law for disciplinary action is taken against him. Once the offense committed by the employee is within the domestic jurisdiction of the employer, disciplinary action in such a case can be taken without recourse to a criminal charge. This is the case of Uzoko and Tax something about so many cases. In the case of Arinze and First Bank of Nigeria, the Supreme Court held that in both statutory and private employment, the employer can dismiss an employee of gross misconduct bordering on crime, and it's not a requirement that he must be first tried in the court of law. The Supreme Court further held that in case of misconduct bordering on crime, all that's required of the employer before the summary dismissal is to give him fair hearing by confronting him with the allegations against him and giving him the opportunity to defend himself. So in the light of the above decision of the appellate court, it can unarguably be concluded that the defendant in the instant case must not wait until the claimant is tried and convicted by the court of law before commencing disciplinary proceedings on the allegations raised against him. Consequently, claimants reliefs number 1 and 3 ought to be dismissed, and I so do. Defendants issue number 2, those reliefs are therefore resolved in his favor.
Escort places.
Let me just go to the end. Ocha and yes, I'm tired.
Escort places, you can see.
Yes, we are going to send the soft and hard copies to you next week.
Escort
Copies of
places.
judgment. Yes. So let me just for what it was, whether the claimant was allowed to call his horse at judge's quarters as his witness or not, the state witness will not be able to give evidence on what actually transpired when the victim of the alleged sexual harassment was in the claimant's car. I find that by virtue of the position of the claimant as the lecturer to Ms. V, his conduct of taking her in his car to his friend's house at judge's quarters and passing the Benin State University and coming back to only drop her at the gate of the university leaves much to be desired. The claimant will not be taken seriously that he does not know the implication of his conduct towards Ms. V. I think the claimant should be above board like Caesar's wife. I wish also to further add that the case of the claimant is not a criminal matter where he would expect the defendant to prove a case of misconduct or infraction against him beyond reasonable doubt, that he wanted the court to believe. Even in criminal cases where the standard of proof is higher, conviction can be based on irresistible conclusion and inferences, while the circumstances of the commission of offense are positive, direct, and unequivocal. See the case of Akpa and the state, Shadali and the state. Claimant's contention in his relief number 2 that there was no credible evidence to establish the allegations raised against him, especially that of sexual harassment, is unfounded and consequently dismissed. For the composition of the disciplinary committee, I observed that the issue was not raised by the claimant during the proceedings of the committee. In fact, the claimant was asked whether he had any objection to the committee, but he answered in the negative. Claimant stated in his statement at page 12 as follows. Page 12 of Exhibit 12. Do you have any objection to this committee on this matter? Claimant, no objection. You can go ahead and treat the case. I think it is now too far late in the day for the claimant to raise the issue. In any event, Section 2 of the defendant's law says that, and I quote, the validity of any proceedings of anybody established in pursuance of this law shall not be affected by any vacancy in the membership of the body or by any defect in the appointment of any member of the body or by reason that any person not entitled to do so took part in the proceedings. Considering the above, I find that the contention of the claimant with regards to the composition of the committee is an afterthought, and its relief number 4 therefore fails and is accordingly dismissed.
As the
statement of the victim are inconsistent. I wish to find that I have not found the statement of the victim before the SSDC and SCC committee with regards to sexual harassment that happened on their way to Judge's quarters as inconsistent. Ms. V had been consistent in the 2 statements that the claimant made advances to her by attempting to kiss her. To me, the alleged inconsistency, if at all it exists, does not actually affect the case of sexual harassment that happened in the claimant's car before the door arrived at the Judge's quarters. See pages 6 and 7 of Exhibit 12. In other words, the alleged inconsistency does not demolish the fact that there are advances made by the claimant to Ms. V in his car, which amounts to sexual harassment and which is the live issue in this matter. Contradiction or inconsistency will not avail any person charged with any misconduct, even in cases that require higher standard of proof although it is so fundamental and fatal, and thus affects the life issue in the matter. See the case of Akpa and the state, Asanya and the state. On the totality of the determination of the issues raised on behalf of the parties and consideration of the facts and circumstances of this case and the events leading to same, I am of the opinion that the decision of the defendant in dismissing the claimant cannot be faulted and is hereby justified. In the end, and for all the reasons I have given above, claimant's case is found to be unmeritorious and ought to be dismissed. Accordingly, it's hereby dismissed.
At court places.
Thank you. I call the next case.
My lord.
It's okay, thank you.
Thank you, my lord.
Let them meet themselves. I just should give them instruction after the calling of it. Let them, they are stored there.
And they are disturbing us. They're not even hearing what you are trying to say. Just call it out. Just
this one is so many others.
Just call one person. Just call one person.
Suit number NICN/MKD/64/2016. Between